I'm sending you a salute. It's good to have everyone here. We'll get started then. So hey everyone, my name is Andrew, and I'm going to be moderating today's event called Watching Over Your Idea, Intellectual Property Demystified. Today, we're going to be guided through an understanding of intellectual property strategy in order to learn why this is important and relevant, and how this can apply to your startup in the future. Today, I am joined by Heather Harper. In addition to founding Harper Legal, Heather F. Harper is also a professor at the Chicago-Kent College of Law and an active mentor throughout Chicago's vibrant startup ecosystem, including acting as a mentor at the Polsky Center for Entrepreneurship and Innovation, NHUB, and 1871. Welcome, Heather. We're really happy to have you here. You can take it away for now.
Thanks for having me. Yeah, thanks for having me. And hello, everyone. Nice to see you all virtually. So we're going to do a couple things today, and please be prepared. There's some interactive parts, but hopefully relatively friendly and not too scary interactive parts. And at the end, I'm hoping that I can tell you about a different case that happened, and I don't know, get you to have a feeling about it, either before or against it. So the first thing I want to do is just quickly explain what the 4 fundamentals of intellectual property are, like the 4 fundamental types. Oh, that's funny. Your wife was like moving, Andrew. And after that, we'll go forward and just try to play with that. So I'm going to ask you to identify some of the intellectual property, and then we're going to kind of play with it and say, well, what happens if we do this, kind of as you start to like monetize your intellectual property. So we didn't figure out a cue. And you want to go to the next one? Sorry, check.
We got it.
Oh, my check thing. Thanks. Got it. So intellectual property, or I'll use IP interchangeably throughout, is very important. And it reminds me of my chemistry, my high school chemistry teacher, who said chemistry is everywhere. IP is everywhere. I think that sometimes people will see IP as only patents, and it's really only specifically to very high tech industries. But really, I'm as I said, a business and startup lawyer, and really every single business that I work with has some sort of intellectual property. So it's important to understand that it's everywhere. It's important to understand that IP really creates value in a business, and monetization can take on a variety of different strategies. So you can license, you can sell something, you can franchise something, you can actually just sell your business or finance your business, and a lot of different ways to make money based on this property. And then also understanding who owns the intellectual property is going to be very important to understanding, obviously, how to monetize it. So with that, and the next one. There are 4 core areas of IP, and yes, the associate that I worked with was kind enough to make sure she had rights in all of these images. So all of the logos are going to be the larger ones. We've got patent, copyright, trademark, and trade secret. We're going to take a look through all of them. At the end of this presentation is really meant to be a tool. So we've put tiny little bubbles in the bottom that'll give you links to either the Kauffman Center on Entrepreneurship's content, their online content on intellectual property, or sometimes the actual USPTO's website. So you can read more if you want to know more about this. Starting with patent, I find that most of the time when people think of intellectual property, they think of a patent, but it's probably its most difficult to get. And it's also probably the narrowest in terms of what, if we had to imagine like 5 business people, do all of them have a patent? A patent has to be novel, non-obvious, and useful. So if you take a look at the elements, patentable, subject quality, novel, non-obvious, and useful. There are several different types. There are design patents, utility patents, provisional patents, and then I think plant patent, which just is there because it's technically one of them. First file and event gets priority. The term of the protection varies, but like for your standard patent, you have 20 years. And what that means is that you have 20 years that you can be ahead of anyone else in making whatever your patentable item is, or you can stop people from creating for patent. It's an exclusive right too. So a patent's really important because what it is it's really you're giving disclosure of a particular invention, and you're trading it for a monopoly from the government. And so it can be very powerful because it's an exclusive tool, meaning one of your monetization strategies may be, I'm just going to sell this to a non-practicing entity who will go and sue people for licenses. I can just stop people from using it. I don't have to build anything. However, you can build a bunch of things, but just after a certain period of time, your patent will be essentially in the public domain and everyone can continue to use that. So that's a patent, the first one. Let's check out the next intellectual property. A trademark. So a trademark is a source identifier, and pretty much every business will have a trademark of one type or the other. So a trademark identifies I'm drinking a LaCroix. It's a sparkling water. You happen to know that this particular brand, like you may or may not drink this brand, but LaCroix, simply putting on here with this particular text shows, I know it's a pretty good flavored one and I enjoy the taste. They don't taste too particularly artificial. In order to get, but a trademark could be a variety of things. So it can be a logo, it can be a slogan, it can be in some cases like something more exotic, like a color. But for the most part, it's something that allows the end user, to identify the source and say, okay, I understand exactly what that is. If the trademarks, when used properly, will allow consumers not to be confused between one product or the other. Good example, who likes coffee? Can we do a quick poll here? Andrew, who likes coffee? Or you can just like shout out who likes coffee, because it's 7 o'clock and
Who likes coffee? Me.
Everyone's like nobody, then I'm going home. I'm done.
All right, pull us out.
Today.
Let's see.
Pull us out.
Pull us
coffee,
out
guys.
right now. Okay. There you go.
I like coffee. I did my own poll. 40% of you guys don't like coffee? Oh my gosh, you need to think of a better example. Anyway, so 40, okay, there we go. We got some more voters. So coffee is a really interesting one. If you like coffee like me, you might hate Starbucks because you think it's kind of bitter. It's a very dark and bold roast. And you might really, really like something like Intelligentsia, which has kind of a smoother and I'd say more European taste and roast. It's really kind of a richer flavor. It's just coffee, right? But for having a brand associated with them, it would be very hard for you to differentiate one of the underlying products from the other because both are coffee. So it's important because understanding a mark and understanding what it's trying to protect will show you kind of how you do protect that. As a business, you protect a trademark by use, at least in the United States. In other countries, it can be slightly different. But use in commerce is what affords protection in the United States. Also, if you don't use your mark in commerce, you'll lose rights in it. And so that happened, I think, a lot with the 90s slogans. It was a really big thing. And then they grew out of fashion and everyone wanted to keep them from nostalgia. But if you don't use it, you lose it. A mark also has to be distinctive. So you can't say beer for beer and expect to get a trademark on that because it doesn't make sense. That is sheerly, generic. You're describing the actual thing that you're selling. You also can't be just merely descriptive. So if it's something like dog pencil, a dog pencil, that's also descriptive. But if you did something that was cute and alluded to something like paw pen, then maybe that would be suggestive. Suggestive and above is protectable. If you're not a suggestive, then you're not acting really as a trademark yet. And there are some ways to try to get to be suggestive or to act as a trademark when you're basically descriptive, but you need to actually have something that looks like a trademark and that acts as a trademark and that distinguishes your goods from someone else's. There are a lot of different ways to designate a trademark. So in the corner up above, you'll see there's the TM, the R, and the SM. And I should have just left those without text in them and asked a poll. Darn it. Missed opportunity, Andrew. But spoiler alert. So the R with the circle around it means registered trademark. And the only time you can use that is if you've filed with the US Patent and Trademark Office and you've registered it and you have the right to use it. Trademark TM means that you're claiming rights in the trademark. And so you could be doing that because you haven't filed your trademark yet. You could be doing it because it's descriptive, but you're claiming use in it. you're trying to establish a secondary meaning in order to get to a registration, or you just be throwing it up because somebody told you it was a good idea. Service mark is juxtaposed with trademark. It's just a service mark is a trademarks technically with the TM refer to a thing. Service mark refers to a particular service as opposed to a good. But that's what a trademark is, and almost all businesses will have a trademark. Let's see the next ones. Copyright. So copyright is important, and this one is one that I think is very, I guess, interesting. A copyright is not an idea. It is the manifestation of an idea in a fixed, tangible medium. Okay, so when you take an idea like a song, and when you write it down and then you sing it and perform it, it becomes a copyright. But it's not a bare business idea at all. It's really just any sort of an expression of an idea. We're going to look at this more closely with the New Girl case that I've pulled aside a little bit later. But the one thing that's so interesting about copyrights is that you can express an idea in a lot of different ways. And so you need to have a basic level of originality to have kind of a copyright. And it can't be just, of ordinary non-copyrightable subject matter. But you can have very low levels of originality to have something different from one another. So giving you a good example of this, by the way, the copyright term, which is really interesting, was generally the life of the author plus 70 years. Right now, it follows Mickey Mouse. So that's kind of one of the areas that it has traditionally followed this iconic little guy and creature. So good examples of copyright are music, photos, and photos are very important because they can actually be very ancillary to your business. You may be throwing up a website or using packaging on a good, and you want to put a photo on your packaging, or you want to put a photo on your website. You have to make sure that before you do that, you actually have the copyright or the rights to do that, because the owner of the copyright, which is the person who took the picture, has the right to figure out and decide where it's displayed, publicly performed, or any derivative works are created from that. Another one is code. That's a very common copyright, like your software code. If you don't have a patent on the overall sort of process, then the code itself is generally reducing that to practice. It's like writing a novel. What are some other good ones? All of your social media. So if you have a Twitter or Instagram or any of those types of things, and you're really driving people to the site, that's all copyright. Believe it or not, copyright is one of those areas of intellectual property that fills the ether. It's everywhere. And the way that we protect copyright is that we generally have people who are providing the copyrights, who are developing them, assign them to the company. So that's copyright. What's the next one? Trade secret. So a trade secret comes in from, I think the best way to think about a trade secret is that it can be juxtaposed to a patent. So if a patent is something that is an invention that is novel, non-obvious, and useful, and when you come up with that invention and you reduce it to practice, you file and you disclose all of how you made the secret sauce, and in exchange for that are given a essentially state mandated monopoly for 20 years. A trade secret, on the other hand, is something that is by definition secret. If it's generally known, it does not qualify as a trade secret. And in addition to that, it has value for being secret. So good examples of trade secrets are, just as general categories, algorithms, customer lists, supplier lists, all almost all recipes, like recipes and ingredients for actual cookies, that's in the slide, for sodas, for drinks, for any other thing like that. Your trade secret could also be your marketing plans or any of the other competitive stuff in your business. And what's important is you get protection only as long as you keep that secret. So you're really not doing anything with that. Okay. Now, with those 4 things in mind, it's really important. And so we have to do some categorizations and start thinking of what are the different areas of intellectual property. And I also want to pause for a second, and this slide is not in here, but I talk really fast, so I have enough time, I'm going to add it. How do you protect and how do you ensure you're not infringing against those? So something like a trade secret, can we do something where people can raise their hands and actually talk?
We can bring someone on stage.
No, I don't want to do it. Does somebody want to come on stage and answer questions?
Let's see, put it in the chat. And I'll bring you up.
Come on, Rob, you're drinking coffee. I'll throw you an easy one.
So Rob, I need you to click on the top right corner. There should be an share audio and video button. Should be blue. So please click on that button and I can bring you up. See, let me know if clicked it. Invite to video call. No, the right button. Oh, there you are. Gotcha. Bringing you on stage. Welcome.
Hi, Rob. Wow. I feel like we just called our neighbor from the old-fashioned game show. All right. So, Rob, what do you do right now? Where do you either work or study?
Oh, yeah, Rob, you're muted.
Oh, I can't hear you.
There. Sorry about that. All right, is that better? Okay. Finance for the day job,
yeah.
But I have a tech startup in the data center space right now. Yes, fun stuff. Lots of engineering fun. Trade secrets. So, and I didn't Google this ahead of time.
Tell us your deepest trade secret, Rob.
A trade secret, for instance,
Pick one.
like proprietary. I just to be, make this fair. A proprietary process that gives you a competitive edge over, a competitor, for instance. Yes, no?
So how do you think you protect? Yeah, 100%. So how do you, as your with your startup hat on, how are you going to go? How would you go about to protect a trade secret?
Well, outside of talking to my IP attorney, I'm not really sure what you're, what part of the answer you're looking for here.
Well, here's a first one. Like,
myself
how many people
and
are
several
on your team
advisors
right now?
and some soon-to-be key hires. Yes.
Okay, so very lean, very new. So one way to protect trade secrets as you grow, that's very hard when you're kind of as a first right out the bat, is you should keep trade secrets kind of to a narrower group. So if something is a valuable piece of information, not everybody gets it. And the only people that get it are those who have basically confidentiality provisions and who you trust. It's a combination. To keep a trade secret, you protect that by both actually making sure that structurally you're keeping it secret. So clean desk policy, having different passwords for different levels of access of things, ensuring that if you're doing things that are secret, you're controlling the computers and you're controlling the hardware and all the different stuff where you develop these types of things. And so that's on the one hand, and that's just sort of like, and that grows over time. I don't know if you've seen like Charlie's Angels or like high tech stuff. I mean, there are certainly highly secure locations that take a lot of structure, a lot of effort to keep that secret. And then on the other hand, you have a contract. So without telling us where you work, because this is me.
My day job?
Do you have a contract where you work?
Or I mean,
job.
of sorts.
Your day job. Take a look at it. This is some free stuff here for you, so keep it up. Your contract probably, especially if you're in finance, you probably have a contract that is has some confidentiality provision and also some intellectual property assignment. And that when you're leaving one business is like, oh boy, what am I doing? Like, I have to be careful that my new business doesn't run afoul of that. But what that does is the confidentiality provision that says you agree that any information that you have that we give you or that you create in the course of your work here is confidential. You will not tell anyone about it outside of the use of providing your work for the business, nor will you use it for any other things. So you're not telling or using. And if you leave, you're going to give us back all your stuff, and you're not going to use that in the future. That is it's a covenant on confidentiality, or a promise that helps protect trade secrets. And then policies of the business, such as making sure that you give back information, like an exit interview, will help protect that in that aspect of it.
I was just about to say, we have
I
all of
bet we
that
can take a look,
actually,
you'll have
and
others.
about the other
Yep.
security related stuff. Yeah, I have an air gapped computer over here for the sensitive information for the IP that's being developed. So definitely, yeah, and NDAs, etc. So yep,
All right.
now I understand what you were getting at. Yep, it's
All right. So I'm going to ask this question a little bit later, but do you? Well, no, that's in the later Q part. You've done really great, Rob. That was awesome. Do you want to keep going, or does somebody else want to come in for a second? We can talk about how we think we protect. Has anyone here been involved in a patent before? Like, does that, like, have you ever filed for a patent? You have.
I'm getting ready to file.
So Rob, you're sticking with me.
3 to 5, depending on how the search goes.
What?
Okay, so how do you protect rights in a patent?
Oh, sorry. You want me to answer? Okay. Oh no.
Unless you're just
That's
like, I've
fine.
had enough.
Well,
but you're on a roll.
I don't want to take over your thing here, but I spent several weeks researching patent law and before I even approached my patent attorney, and just understanding what I could patent, how patents structured, and utility versus design patents, and just making sure that what I was developing, I wasn't wasting my time. And so it didn't make a whole lot of sense to spend many thousands of dollars and many months working on something that I couldn't patent in the end. And so I started with that first before I secured my
Right.
my current IP attorney.
Right. Great. So just to even sort of synthesize what you're saying, like, patents have to be filed. So, and that may seem like, oh, obvious, especially in this particular group, but trade secrets are not filed. Trademarks may or may not be filed, and copyrights may or may not be. Patents have to be filed, and they have to be prosecuted, and they cost a bit of money. So they truly are intellectual property that you have to take a very proactive effort to get. They're not of right. You don't sort of get them because you came up with an awesome idea. You get them because you came up with an awesome idea. You sketched that awesome idea out. It was a patentable subject matter. There was no prior art. And you gave this invention to the world, and they gave that back. So that's how you protect a patent. That's pretty straightforward. Do we have anyone else that wants to talk about trademark and copyright, or should we keep Rob going, or do you want to hear me talk?
You have much more interesting stuff to say than I do.
All right. All right. Well, then, thank you, Rob. I appreciate your participation this evening. We'll let you go back about your afternoon, or I guess it's late evening, wherever it is. So with trademark and with trademark and with copyright, trademark is something where you need to have use. So you get rights in the US by using that, but you really generally want to ensure you file that. A trademark filing can take up to 9 months if there's really nothing going wrong, just because there's a lot of a backlog, and really much longer after that. So that's how you get rights in a trademark. You can have common law rights in a trademark based on use, but they only exist in the geographic territory where you're using them. It's not a hard process to trademark a name or logo, so it's a good idea. With copyrights, those come into existence as soon as you put whatever expression of an idea you have into a tangible medium. Now, it's a good idea, depending on the type of tangible medium, to file. So with music and with works of authorship, you'll see, and oftentimes like the traditional copyrightable things like movies, music, books, you'll see that publishers and producers will actually file for that. And that's because you get greater damages and rights if somebody infringes if you file within 3 months of use. But you don't have to. And most of the time, the way you get a copyright is it comes into existence, and you, as the owner of a business, have a contract, that exact same contract that we were talking with Rob about, what's called a proprietary information and innovation agreement or a non-disclosure and development agreement, whatever that is, it says all of the assigned work goes to the business, and it'll oftentimes have language that says anything you make that is copyrightable is a work made for hire, which is a term of art in copyright. And if it isn't, you're going to assign it to the company anyways. So these are couples of different ways where you, as people who are starting businesses or working with businesses, you will either assign your IP or ask everyone else to assign IP, but beware, or at least just be mindful about who owning IP is important, remember? So when you leave your day job, when you leave your academic post, like if depending on where you study, you have to ensure you know who owns the intellectual property, or else you may be owning intellectual property that is awesome that is not owned by you, and that's not good for your business. Okay? Let's keep going.
Okay, we have the activity.
So now we're doing
Awesome. Okay.
name that IP.
Yeah, go ahead.
So oh no, I don't know how to voice over this, but we decided to do a Coke themed intellectual property one because they had a lot of it. So Andrew's going to circle this one, right?
Oh, one more. Oh, sorry.
And one more.
Yeah. Okay.
Yep. Circle the next one. Okay, guys, it's up to you. There are 4 types of IP. Remember, trade secret, trademark, patent.
We have a poll up for you guys.
Copyright. You should do your poll. Name that IP. I should have had like rewards or something, like fun things. This is not. There's no like
votes.
Positive feedback to it. All right, I don't see them. Oh, I have to vote.
We have a 100% on
That's
trademark.
why it didn't tell me. You guys are killing me. I'm going home. I don't need to work anymore. You guys take it over. Put your email in the chat. I'm going to send you work. Yes, it is a trademark. On the top, we've got a clear stylized name, right? So it's the name with the stylized text. And then we have Taste the Feeling, which is a slogan. Nailed it. Because I love that show. I'm watching that one again. All right, let's see the next one. What's inside the bottle?
Let me put that IP.
Name that IP.
Poll up again. There it is.
All right.
Okay, the distribution here is a little bit different. And let's give it a little bit more time. Okay, Heather, can you see the results?
I can. We're looking for. All right, this one's close. This one's a nail biter. It's very close. So we've got 2 saying trademark, 4 saying trade secret, 3 saying patent and trade dress, and 1 copyright. It's very good. This one refers to the ingredient, what is in the bottle, which is Coca-Cola. And Coca-Cola is the best trade secret. So the secret ingredient for Coke is known by but like 2 people who can't fly in the same plane together. And it is extremely, extremely closely guarded. The secret sauce of what is in Coke. I should have done who likes Coke or Pepsi better, but alas, didn't do that one. All right, let's go on to the next one. Now, what do you guys think about this? Like the bottle. What's the bottle?
You have another poll up. Let's see. Okay. Okay, the votes are coming in.
All right. I can't remember. Are we getting 9 or to 8? Not like I'm like putting everyone on the spot. I'm going to go ahead with this. We got 7 votes for patent and trade dress, 1 for trademark, which I think is actually a good one because, believe it or not, trade dress is really, it's kind of a subset of trademark. So everyone's right here. Yeah, the bottle itself is actually is a design patent, which is relatively unusual in terms of you know, the using it for marketing, which is why there's also the trade dress behind it. And we'll look at it later when we look at sort of how the IP of Coke kind of developed over time in a market where there's just like one brown soda over the other. But that's right, patent and trade dress. All right, last one, guys. What's the whole thing look like? Like if we just had to look at this entire image. This is an ad. This is an ad. You guys are right. Everyone's got it. That's a copyright. Exactly. So it's copyright because it's photo, it's an expression of this idea, like all of the actual like end result kind of ad is a copyright. So spectacular. Let's go to the next one. More true and falses. All right. All ideas are considered IP. True or false, guys? I didn't realize this would be so rapid fire for you in terms of the...
Let's put those polls together real quick.
Let's put something in between them.
Okay, pull this up.
Yep. All right, guys. True or false? All ideas are some sort of IP.
Yeah.
Well, I don't see the poll.
I gotta delete the other ones. Yeah.
Oh, too many polls.
Wait on those results while I clean up poll column a little bit more. And okay.
So this was kind of interesting because we should have probably made it a little bit less true falsy so that it wasn't so one-sided. But the answer is like false, obviously. Ideas are not intellectual property. But I think it's really important to remember that as you're creating your product and your idea and your business idea, because I talk to a lot of people and most people want their ideas to be intellectual property. It's really natural when you start a business, especially for the first time. And I don't know how many of you are first time entrepreneurs, but it's very natural to want to try to protect your idea and hold it really close to your chest and say, oh, this is super special. I don't want someone else to take it. And how do I protect that, right? And I get that question. And what I always answer to that question is, what are you trying to protect, right? You should always, instead of saying, how do I protect it, go back to what is it? Are we talking about a trademark? How do you protect a trademark? Use it. Are we talking about a trade secret? How do you protect a trade secret? Keep it secret. Don't tell anyone. Put it somewhere else. Are we talking about a patent? How do you protect it? Well, you make sure to file it and make sure that you continue to have novelty before you file it. Are we talking about a copyright? Then how do you protect the expression of your idea? And like, what is, what type of an idea and an expression is not really protectable? So that's one that I think is, as you kind of develop and look at things, use the first framework to try to get to the second part. All right, next one. A company does not automatically own the work of its employees or contractors. What do you guys think? Does a company own the work? Well, I have to ask it in the way. A company does not automatically own the work of its employers or contractors. Some of us are uncertain about this. I should have had an uncertain. I don't know. The answer is, it's true. A company does not automatically own the work of its employers or contractors. So for instance, it is true that if you are hired to invent and you make a patent, that generally your employer will have the rights to that patent. If you are using your employer's workspace while you're inventing something on your own. They might have shop rights. If you have something where you are making something as a work made for hire and you're an employee, they may have rights for that. But if you hire, most notably, a contractor to make something for you, and you don't have work made for hire language in a copyright agreement, or some sort of, oh, I like the insure, or some sort of IP assignment, you don't generally own that. And so it's very important for all founders to remember that, and to ensure that every time you have someone building your intellectual property, you should have a written contract where they assign that intellectual property to the business. And where you're assigning intellectual property, you should be darn sure you're not over broadly assigning intellectual property to someone else. All right, what's the next one? If it does not have a copyright symbol attached to it, it's not protected. What do you guys think? If it does not have a copyright symbol, meaning if you see something without a copyright on it, you can rest assured there's no copyright. All right. Reveal the answer. You do not need to have a copyright protection symbol on it. It's false. You can, a copyright comes into existence just at the time you fix it in the tangible medium. So putting a copyright symbol on it may assert that you have rights in it, but it's outdated that you need to do that in order to assert rights in a copyright. Not only that, if you haven't filed for a copyright and somebody infringes on your copyright, you can actually file for the copyright immediately prior to filing an infringement suit. So you have a lot of protections as the creator of a copyright. What's next? A patent grants worldwide protection. True or false? A patent grants worldwide protection. This one is false. So 7 of you said false, 2 said true. You need to file internationally in order to receive protection internationally. So this is also true for trademarks, by the way, and the regimes are slightly different in these different jurisdictions. One thing to remember about patents is that in the United States, remember how we talked about novelty being one of the elements, meaning it has to be new and no one knows about it, which makes sense if you're giving someone a monopoly in exchange for disclosure. It should be something new that you're disclosing. It's not the case that you get 1 year or the statutory bar period to actually you're finished with internationally. If you've disclosed it, you might be kind of done. So it's different in different jurisdictions. All right, moving faster. What's the next one? To be classified as a trade secret, the information must generally not have been shared with the public. True or false? Trade secrets must not be shared with the public. Yep, true. It's got to be a secret. You actually have to have it be a secret. If it's not a secret, it's not a trade secret. Okay, next one. I can freely use a photo I grab on Google as long as it doesn't have a watermark on it that says someone's name or a copyright logo on it. True or false? True or false? I can freely use a photo as long as I don't see someone has a watermark or something. Where are you? I thought I had everybody. That's right. I think all of you guys got that one. No, you can't. So photos are potentially the most risky of the I'm going on Google and pulling something, especially when you're doing your own business. You need to ensure that you own the copyright in order to do what you'd like with it. All right, I think we got the last one now. Non-disclosure agreements are unnecessary if I trust my employees, partners, customers, and suppliers. So I don't need them to protect trade secrets and such. as long as I trust these people. True or false? All right. Resoundingly false. That's right. There are a lot of different ways to use NDAs. One of them is to protect novelty for your patent. You always need that, whether or not you trust someone. And the second reason is because something actually has to be secret for it to be a trade secret. So that means that an NDA is going to be a floor, not a ceiling. So you guys did great on those. Let's see what the next slide looks like. So this one is actually a lot, and it looks really kind of interesting. I'm going to very quickly take you through kind of just like, and we did this in the earlier one, but just a company's intellectual property journey. And I'm going to do this very quickly because I want to talk about New Girl, and I want to hear your thoughts on the other kind of aspect to it. So Coca-Cola was originally started by this pharmacist in the 80s. And it was made under my poor associate who put this together. She's like, there's no patent on the original ingredient. And it was what's called a patent medicine, which is not a patent. It's just like a type of elixir from the late, 1800s. So they founded the company and they received the first trademark a long time ago. Then Pepsi came on the market, and at some point, consumers started getting really confused right around the turn of the century. So at that time, even though they had a trademark for Coca-Cola, Coca-Cola didn't think that it was easy to differentiate one brown soda on the market from another brown soda. So they had a competition to try to figure out and design the most unique bottle that you could tell by feeling and touching it, and you could see it lying on the ground. And when they got that, they filed a design patent for that, which has been their kind of iconic look and bottle that doesn't have, it's really only for design purposes since that time. It was really to differentiate itself in the market. Then throughout the, late 60s and then up into the early 80s, they tried to reformulate their ingredients and see if they created new products and new trade secrets, all to find out that at some point those failed. And their original best kept secret from, essentially the original ingredients is what's kept this as a secret for whatever. Now, what's interesting is even if this had been something that was patentable, you can see we're in 2021, and this was created in 1886. You can keep a trade secret for a really, really long time, and they go through extraordinary efforts to do so, but it's very different. And then at some point, you may actually need to find yourself, availing yourself of lots of different types of intellectual property. Also in here, I didn't go through and take a look at it, but there are, I'm sure they have hundreds of trademarks of all different types of products and different looks and feels of things and slogans too. So it's just kind of a quick illustration. The last one I want to talk about as sort of an example is the New Girl case. And the link to the case is in the back. And we've set this out into just a quick briefing. And I try to make this as friendly to the non-lawyer as possible. But basically, we had two different creatives, Counts and Gold, and they came up with a script called Square One. And they were working with and pitched the script. They were working with Holly Harper. And they pitched the script to an agency, World Morris. The agency looked at the script. They scanned it into their system. They're like, oh, this looks pretty good. And for one reason or another, this, the person shopped it around, but just, the agent didn't really get this done. So the agent and the creatives went their separate ways, right? At some point a little bit later, New Girl came out, and to the original creators, Counts and Gold, they were like, hey, this looks very much like my show. So the issue was Square One's fundamental question is, do we have copyright infringement? Which came down to two things. One, did the people who were creating the second script have access to the first? And then the second is, were the scripts substantially similar that one was actually really a copy of the other? And so that's the issue, was whether there was copyright infringement. The rule was just as I told you. And what's interesting is that the court here held that while there were some similarities, first of all, there's no proof that even though both of them They might have had access because the new creator was working with the same general agency. There was no evidence that they actually had access to the exact same script. And so it was really just more you'd have to kind of guess that they had. But the next thing is they also looked at, and I have this in a separate area, and it was too big to put on, but if you go to the next slide, they actually found that they weren't that substantially similar. So the new girl, there's basically a girl in her 20s. She moves into a bachelor pad after finding out that her boyfriend was cheating on her. In Square One, there's a woman in her 30s who moves into a bachelor pad after finding out her husband is cheating at her. It is true that they're both named Spencer. So run from Spencer's, I guess. Jess, in New Girl, Jess cries and watches Dirty Dancing and whatever else. And I'll read down the one side, and she tries to recover, but she can't really. She drives into the airport. The first episode, this is really like the first episode only. It's a breakup story, right? So Jess tries retrieving her belongings from Spencer, but Spencer asks Jess to drive the new girlfriend to the airport, and she complies. After trying to get her belongings several times, the roommates accompany Jess to Spencer's home, and they help her move out. In Square One, she was a married woman who had, went to a baby shower later, and they tried to get back together and then realized there was another woman involved, and so she didn't go back together and whatever. Now, what's interesting about this is that in some ways, they're the same story, meaning they're the story of two people who, basically at the end of a relationship in a rather unfortunate manner. But what the court held was really these were just tropes. These were like standard characters. There was the girl who got cheated on, the bad guy ex who may or may not have been married, the friend who was there to help, and then these like very superficial guys. And as such, the court found that there was no copyright infringement here because they weren't even substantially similar. They were really just sort of the same ideas. So here's the question. I don't know if any of you have heard of that before, but now that I kind of talk about that area, that topic, this case, does that remind you guys of anything that you're worried about or you're thinking about, or what do you think about it? Is anyone willing to come up and chat about this one with me for a minute?
So remember, if you want to come up on stage, you can click on the top right button. It's blue and it says share audio and video.
I think you want to. Or you can put in the chat, I'm nervous, I'm scared, and need a little bit of encouragement, and I'll give you some encouragement. Andrew, they're like, I don't want to do it.
Yep, go ahead.
All right. How about this? Can I steal you for a minute, Andrew? All right, we're gonna do this. So just knowing just what you know right now, not very much. Do you feel bad for the creators of Square One in that they had this awesome idea, and from a bargaining position, they didn't have anywhere near as much bargaining position as the studios and as much as the agents, and they gave their idea and their IP, their copyright, to this agent. They didn't get money made. They didn't get any money out of it. They didn't get their show made, and then some show that looked just like theirs was made.
Well,
what do you think? Are you feeling bad
I
for
don't
them?
really think
Are you
it's
like
such an awesome idea. I think it's kind of like a cliche story. But if I were to be them and actually think that it's this awesome idea, I'd be pretty upset. Yeah, and I would try to get some sort of case going, but didn't pan out.
All right, guys. So Andrew thinks it's a cliche idea and not that interesting. Is anyone going to take the other side and be like, hey, actually, but they had the same characters. They had, the three guys at the bachelor pad, and it was more than just that. I feel like lawsuits are everywhere, and it's discouraging to make content. All right, Brian. Yeah, it is discouraging to make content, right? So here are the two sides of the story that I think I'll chat with, and I would love for someone to take me on with this because I think it's an interesting conversation. Ideas, there are a million ideas out there. And when you're like deeply in your idea, when you're deeply in like, I'm gonna make Square One, you probably don't realize that actually it is a relatively common phenomenon and idea. And in fact, Andrew, New Girl was made based upon inspirations from Three's Company, if you read the the case and what they said. But to the creator of Square One, this was her life. This happened to her. She actually was like, wait, but you stole my experience and my idea, and it felt so real, and then you changed a couple of things. And I think this can look really similar, like when people are pitching their ideas to different people, and they're not pitching their patents and showing things how they're done, and they're not doing X, Y, and Z, but they're saying, I have this idea, and it's so unique and it's so different. And actually, like when it comes to copyright, the answer is it's not really that unique. And it really is sort of common, and a lot of people do have it. And so while you feel like, okay, I gave this story to this particular producer and they made it, someone else independently came up with that exact idea. And so kind of understanding like what you have at different moments and what is protectable, and that bare ideas and bare business ideas, and frankly, really common, really like tropes of people and like ideas are also not protectable, or at least they're very low and minimally protectable, I think will help you actually focus on what to create and what to protect and how to protect these different things in different moments. So that's what I've got. We've got 5 minutes at the end now. If we have questions or
Yes,
Andrew, if anything that you need to do to wrap this one
you
up,
got time to go over them.
Hopefully,
we should be fine.
Oh, I guess I wish I had, sure. So we do a couple things in terms of resources. Like I run a law firm for growth stage companies, but at Chicago Kent, we also do two other things. So I also run a clinic that represents early stage entrepreneurs, and we do like formation and audits and all sorts of really cool stuff with students. So that's a lot of fun. That's not pro bono, but it is low bono. It's like a very good deal, and it's meant to be. The Patent Hub is 100% pro bono, and if you haven't heard of it and you have any interest in figuring out if something's patentable or getting to good pro bono patent counsel, I strongly encourage you to take a look at the website and avail yourself of that service. It's amazing. It's actually a USPTO program, and so we've got both of those here at Chicago Kent, which is obviously Illinois Tech's law school. And then the last one I think is just me. It's like a picture. I don't know. If you have additional, or maybe it's, yes, and then that's me. That's how you can get a hold of me. And then on the very last slide, we've got resources. So if you're interested in reading more about this stuff, you don't need to actually look at that. You can take a look and go, I don't know, dig in, engage with some of the stuff.
All right.
So that's where we are. Does anyone have questions they want to, or stuff that they didn't get answered? Now's the time.
I do have a question for you, actually, because I want to be an inventor myself, and I've been to this Patent Hub website, and they got like some sort of application there, but I'm not too clear on whether you need to have the idea like pinned down first, or do you need like a prototype to apply to it, or like what's kind of the stage that you need to be at so that you're kind of like eligible for this Patent Hub program?
Well, I don't run it, so I'm going to go off the top of my head, but I'm going to say I could be wrong. But the general idea of it, and I was around when they were putting it in place, is that you have to have a patentable thing. So you have to be like more than just wanting to know about patents. Now they do a lot of good programming, and you should try. It's COVID, right? Like, but it's coming out. We're coming out. But take a look at the programming, which is more in the educational realm. But generally, you have to have something that is that shows that you've got like some sort of process. So you've done some education, you have something in there that is like that. If you were to be passed up to pro bono counsel, they could file some sort of a patent. We do help. Yep. We do help with NDAs. What are the core components of an NDA that will make something non-binding? Well, an NDA stands for a non-disclosure agreement, which is a freestanding confidentiality agreement, and they're generally quite enforceable because oftentimes, so what could you put in it that would make it unenforceable? I guess you could put a lot of things in it, but in general, like non-competes and non-competes generally tend to be less enforceable, and those you wouldn't generally find in a freestanding NDA. The core components of an NDA are defining confidential information as basically anything confidential that's not publicly known, discovered independently, or known before creating whatever you've done. The covenants around the confidential information, meaning I'm not going to tell anyone, or I'm not going to use it for anything other than the purpose you provided, giving the purpose as to why you've given the information, figuring out who the person who's receiving the information or the entity that's receiving the information can share with, those are typically called representatives, and then all the stuff around that. So how long the obligation lasts, when it terminates, governing law, what happens if somebody breaks their obligations, and you can get a protective order. And they're, depending on how you're using them, they can either last for quite a long time or for less of a long time. So there are different uses of NDAs. I love talking about NDAs.
All right, that was awesome. I think
NDAs
we're 1 minute to go, so I'll closing remarks over here. So thank you so much, Heather. This has been amazing. As I mentioned, I'm currently working on my own startup, my own ideas, and I will definitely use everything we've learned today in the future. So I want to encourage everyone here in the audience to head to the main stage to our final event of the day, the virtual happy hour. And no, it's not going to be alcohol unless you have it around via Gamer Jive. In order to get there, please click on the stage to the left-hand side. Am I pointing to the left here? Because it's kind of mirrored. Left-hand side, click on stage, and you'll be guided to Gamer Jive from there. As always, it's been a pleasure hosting here. And Heather, have a great night.
Everyone for coming. Thanks for having me. I hope you have a good one.
Okay.
Bye.
All right. Bye-bye. I'll just stay here until everyone moves to Gamer Jive if you want to go ahead. It's going to be pretty fun. It's kind of like this virtual entertainment platform. It's pretty cool, actually. It feels like using Minecraft of sorts. But yeah, it's pretty cool. So definitely go check it out. It's not like Minecraft. It's like Roblox. You guys familiar with Roblox? I think it's pretty good. Oh, 3 people left. Okay. Okay, yeah. Go ahead and check out Gamer Jive. Stage. Click on stage here on the left. You gotta point right because it's mirrored, but to the left. There. Okay. Awesome. I'm going to go ahead and close this call. Thank you for being here. Thank you for joining. And I'll see you around. Bye-bye.